Awesome, Brent. Thanks for joining us again. I know we've had a great conversation in the past. We just have a few more questions for you. I'd love to get some answers for people looking. So the number one thing we're kind of thinking right now is with blended families. So say second marriage or anything like that. Does that change estate planning, and what do we need to be watching out for on that side of things?
Yeah, I'm glad to be here and thank you. It does change things. Blended families are tricky. There's an inherent conflict between the spouse and children from a prior marriage, and we can talk about any aspect of that you'd like. But it does take some attention and pre-planning.
Yeah, so like what are the planning dynamics we need to go through with that? Like what, specific details, does it change things if it's one person in the blended family has had a prior marriage or both? What are the specific details that, somebody who is first time marriage to someone who's on their second marriage versus two people on their both on their second marriage, if that makes sense? Or does that matter?
Well, that's not quite so important as just making sure that everybody's accounted for. So the answer to your question really is it depends, just
Yeah.
like everything
Yeah,
else,
yeah.
right? So let's say husband and wife have let's say husband has children from a prior marriage, wife doesn't. Um, if the husband dies, that's the question, right? What
Mhm.
happens to his assets? And the short answer is whatever he wants can
Can happen.
happen. The default answer usually is that if he doesn't do any planning, what he wants is probably not what's going to happen.
Mhm.
So there are two things that kind of come into play here. One is, does the husband have a will or a trust or anything else? And
Yeah.
if not, you get a certain outcome. Does the husband have a will or a trust? And if so, then another outcome happens. So let's talk about what happens if he dies without a will. So if he dies without a will, that's called dying intestate. And in that case, just by virtue of being married, his spouse is entitled to half of his estate plus $75,000.
Mhm.
So let's say he's got $1 million estate, a house and life insurance. Well, life insurance might be a little bit different, but let's just say it's $1 million estate. Um, he gets 507, or the wife, surviving wife, gets $575,000. The children get $425,000. Doesn't matter how long they've been married.
Wow.
So now that's often a desired outcome. Most of the people that I work with, they
Yeah.
want to make sure that their spouse is taken care of. That's the main issue, right?
Yeah.
But they also want to make sure that they don't disinherit their own children, or that at least they're deliberate about what happens.
Yeah.
All right. So you want to make sure that what happens is what you want, then it's not just a default that you haven't thought through.
Yeah, and to me, that also sounds like, say they did have an estate set up with their first wife. If they don't get that updated, it all goes to their ex-wife at that point. Is that correct? Or whatever structure they had set up.
Yeah, no, there are laws in the books here in Utah that act to take an ex-spouse where a divorce has happened off of an
Okay.
intestate,
Okay.
and usually write them out of the will. But you don't want to take that chance, and you
Yeah.
don't want to invite the litigation. So you should get it updated.
Okay.
And that brings up the question of, well, so in that same scenario before, if husband has $1 million estate and he marries, and wife comes into the marriage without it, and I've seen it both ways, where wife
Hmm.
comes in
With
fairly
money.
wealthy and the husband really doesn't have much. So it's the same scenario either way. But if they do have a will or a trust, the law prevents one spouse from writing the other one out of the will
Got it.
unless the other spouse specifically and in writing makes a knowing waiver of that.
Mm.
So in that case, let's say husband does a will or a trust and he says, I have $1 million and I leave $100,000 to my wife and $900,000 to my children. Well, the wife can say, no, I'm going to do what's called the elective share. And I'm going to elect to take 1/3 of the estate because I'm entitled to 1/3 of the estate, not just what he leaves me.
Mm.
If they had thought about that beforehand, they could have made different arrangements.
Mm.
A prenuptial agreement or a property agreement or a postnuptial agreement, any of that would act to waive those rights. But without thinking it through, um,
You're not in control.
you're not in control. And actually, something that's even more common than that is if you're not clear about your family situation when you're doing this, or if you're trying to do it yourself and you don't really pay attention to the forms you're using,
Yeah.
the typical will or trust leaves everything to the wife or the
Hmm.
husband. Generally, they're reciprocal, and husband leaves everything to wife, wife leaves everything to husband. When the other one dies, then everything goes to the children. The problem there, and this is especially true if you have a husband and wife and they each have their own children. Okay, you see what I'm saying?
Mm-hmm.
Husband leaves everything to wife. Well, everything belongs to the wife. There's nothing that would prevent her from changing her estate plan and leaving everything to
Her
her
kids.
children. Vice versa, him leaving
Mm-hmm.
everything to his children.
Mm-hmm.
That's very common.
Mm-hmm.
And it's not that there's anything nefarious there or trying to do, but as time goes on, let's say the wife died, and 15 years later, the husband
Right.
just hasn't kept in same contact with the stepchildren as he did with his own children, and naturally he's going to feel some more affinity there and is going to leave
Yeah.
the entire estate to his children.
Right.
That happens a lot.
Wow. Yeah, I hadn't even thought of that. And that
Yeah.
kind of brings up another question. I know the last time we were chatting, you had mentioned like a lot of estate software will just use kind of a simple blanket form. There's a
Mhm.
lot of problems with that. That's one big problem for, blended families is, leaving everything to the spouse. And then depending on how that blended family situation goes, it might go to their kids versus your kids.
Yeah.
Are there any other standard template problems? Like, obviously, we know we should go see an expert like yourself, but what are the other standard problems that you see common pitfalls with blended families?
That's the main one that gets
Okay,
in the
the
way,
biggest
is
one.
just the default that everything goes to the spouse without really making arrangements for that spouse being the
Yeah.
owner of everything. And this one isn't so much of a software issue, but you got to keep in mind that there are a lot of assets that pass outside of a will and a trust
Yeah.
that are not subject to the probate process, that may not be part of what you're thinking about when you're drafting the documents. But
Yeah.
those are things like life insurance policies, 401k plans, IRA plans. All of those are beneficiary driven.
Mhm.
So whoever your named beneficiary is who's going to get that, regardless of what the will says or regardless of what the trust says.
Mhm.
So, husband could leave everything to his wife in the will. There's an IRA out there. If he's named another beneficiary of the IRA, that's likely going to become the subject of some litigation or some hard
Mhm.
feelings later on.
Yeah.
Um, in that event, the wife still has rights to the IRA if the IRA is going to, make up whatever the shortfall is in
Mhm.
that elective share.
Yeah.
But you've really got to pay close attention to what those beneficiary agreements say.
And that makes a ton of sense. Like outside of that, are there any other unintended outcomes of not having a thorough thought through plan? Or are those kind of like the main, it sounds like those are kind of the main ones. Is there anything else that blended families should be watching out for?
Yeah, it's keeping those relationships clear. It's not so much trying to foresee problems
Mm-hmm.
as it is trying to prevent them,
Yeah. Right.
with the correct documentation. So the natural tension is, how do I make sure that my spouse is taken care of,
Yeah.
but at the same time be I don't want to use the word fair, because there's nothing in the law that requires us to be
Right.
fair to our family or to
Correct.
our children. It's entirely reasonable to leave everything to a spouse and write children out.
Yeah.
Or it's less reasonable, in my opinion, to try to write out a spouse, especially in a long term marriage
Yeah.
where there hasn't been maybe equal earnings. You want to make sure that at least the outcomes are fairly equal.
Yeah.
And Utah law does a good job of
Helping outline that.
favoring that,
Yeah.
right? But but you cut this. I mean, I've kind of lost my train
No,
of
you're
thought.
good.
Where
You're
was I
good.
going?
Um, Other unintended consequences of, like if we don't plan well, what are the
Oh,
other unintended outcomes?
Yeah, there are trust documents and trust structures that will help a family take care of both parts of that spouse
Okay.
and children relationship. So, for example, if you would like to make sure that your spouse has a place to live and money to support the home,
Yeah.
there are provisions you can write in a trust, there are life estates you can grant, things that will give that spouse an enforceable right to occupy the property. And they can do that until certain conditions are met, until they die or until they get remarried or until they choose to move out of the house or whatever else. And money can be used to pay the taxes and the upkeep and everything, keep it in good shape for the
Hmm.
trust and for the children later on. And then when that spouse passes away, the home is there for the children, but in the meantime, the surviving spouse can live in the property. And if that's done right, then that right to occupy can be valued and made part of the elective share,
Yeah.
so that the right to live in that house rent free is calculated. And okay, that is up to one third of the value of the property of the augmented estate. And that counts towards what you would otherwise have to leave for that spouse. That's a simple way of doing it. There are actual trust
Mm.
structures where when one spouse dies, um, a percentage of the estate or assets from the estate go into a separate trust that was kind of, it's called a Q-tip trust.
Mm.
It's held separately. The surviving spouse can draw income from that trust, maybe can draw principal from that trust as well, and you can put conditions on that. But the surviving spouse can't change the beneficiaries of that.
Got it.
So you might leave a large sum of money or even a home or a property in that trust. The spouse can use the income from that for her living expenses or his living expenses. And but they can't go and say, well, I want the beneficiaries for that to be my children or anybody
Yeah.
else. Those stay in the same. And it's just that the children of the decedent maybe have to wait a little bit. But look, it's not their money, right?
And they're taken care of.
They're
Yeah.
taken care of in the end. Dad or mom didn't write them out of the will. There's no
Yeah.
unintended consequence there. But it's reasonable and expected that one spouse will care for the other.
Yeah.
And I always approach this from the perspective that this money doesn't belong to your kids.
Yeah.
You know,
Yeah.
they're not entitled to anything.
Yeah.
And for those kids who are out there listening to me say that, I mean, it's not that most people that I work with understand that and come
Yeah.
with that outcome too. We're trying to make the outcome desirable according to what the parents want,
Absolutely.
and not have it be something where people fight about it later, because
Yeah.
nothing depletes an estate
Faster than
faster
litigation.
than
Yeah.
litigating over stupid stuff that could have been resolved before anybody passed away.
Yeah. No, that makes a lot of sense. And it sounds like the biggest unintended consequences is that litigation depletes your resources, right? It's like
Yeah.
yeah, no, that makes a lot of sense.
And it's funny what people fight over.
Yeah, and you
And
just never know.
and especially like in the case of a blended family situation, there may be heirlooms or
Mm, yeah,
sentimental items, and it happens often where a spouse will die and the surviving spouse locks the doors, and the stepchildren, the children of the decedent, can't come in. And that's usually from a place of fear on the surviving spouse's side. They don't want them to come in and take money. I've seen it also where the parent died, the surviving spouse is out of the house taking care of funeral arrangements.
yeah,
Kids move back up a moving truck,
and just unload
empty the house of all the furniture, everything. Surviving spouse comes home
to nothing.
to nothing in the house, and the kids have raided the house and taken everything. Now, that was in that particular case, that was a fairly short-term second marriage. They hadn't been married for very long, so there was no trust and no relationship, and that's a really hard situation to be in.
Yeah,
And it's a terrible, in my opinion, it's a terrible way to behave.
yeah, I think most people would agree with you on that one.
But uh, and I would just say, surprisingly, a lot of people don't.
Yeah,
They're
really.
they're going to make sure that
They
they're
get theirs.
see. Well, it's not just that they get theirs, but that um, a new person or some new family member doesn't come in and take advantage,
Yeah.
you know, and pull out assets that the family has been
Accumulating.
accumulating
Yeah.
for a long, long time.
Which that I can agree with. Like
Yeah.
that scare, that fear, that makes sense. The reaction, maybe a little more than you should have. However, I
Yeah.
guess we can empathize with that a little, right?
Yeah. And it's that fear that drives these decisions. And so you can do a lot to overcome that fear. First, by the relationships that you have with your family, right? But second, by the documents.
Yeah.
Good fences make good neighbors. So
Agreed.
yeah.
This one is kind of something that we've touched on, and maybe I just want to make sure, like, for any of those that have it, they look at the right structure and come talk to you and make sure that they get this. But if there's, children from a prior marriage, maybe it was stepchildren at that time, and now they've separated, they're in a different marriage. How do you make sure that you either don't disinherit those children if they've been your kids for a long time and you don't want to cut them out of the will unintentionally, or maybe it is something where you're like, I want to make sure this goes to my kids and not equally between, my stepkids and my
Yeah.
kids. What's kind of the process to make sure you get that right?
Well, if you find yourself the owner outright of any particular group of assets, then as the owner, you have the absolute right to
All power to,
dispose of those however you see fit.
okay.
And yeah, I have seen families that have been very careful
Yeah.
in the absence of these Q-tip documents and in the absence of any of these protections.
Yeah.
I'm thinking of a family where the wife was really, really careful over a period of 20 years to protect the assets that belonged to the children of her deceased spouse.
Yeah.
And she was really faithful about that, like
Diligent. Yeah.
really diligent about
Great
making sure
steward.
that happened. But she didn't have to.
Yeah. Yeah.
She could have done whatever she wanted.
So it's really just setting up those Q-tip documents. Is there? I feel like I'm going to miss a name there, but the Q-tip documents and anything else. What was the?
Yeah, so that's a type of trust.
Okay.
So it's a revocable living trust that has Q-tip provisions.
Got it.
Q-tip is qualified terminable interest property
Got it.
provisions. It just means if it's property set aside and the disposition of that is set in stone and
Got
it
it.
can't be changed.
Yeah, and that protects the children. So, like we talked about
Yeah.
before, the spouse can maybe draw certain principal or certain things from it, but can't change who owns or is a
Who the ultimate beneficiary is.
beneficiary of the estate.
Yep.
Thank you.
And she can draw income or he can draw income from it. They can also draw principal, but you can put a restriction on that and say you can't draw principal from this.
Or only X amount.
Yeah, principal can only be this much, or you can't draw principal if you get remarried unless you execute a prenuptial agreement that specifically protects trust assets so that we don't tie up trust assets in a divorce of a second marriage after I mean, it can get
messy,
it can get
and
wild,
complicated. Yeah.
So
Yeah, that's why we go talk to you,
Yeah.
right? At the end of the day, it's like you need a professional that understands the law and can have your back.
yeah,
Yeah. And then it sounds like there's a lot of ways of just eliminating who can change or add, beneficiaries, but saying what is exactly what we want to have in place. Is it just those Q-tip documents for surviving spouse and estate protection, or is there anything else that we should be aware of on? I want to make sure my surviving spouse does not change the beneficiaries of these.
Yeah, well, where that's most likely to happen
Yeah,
is with an IRA or a 401k account.
got it.
Because with current law, you can't name the trust as the owner of that IRA.
It has to be within the beneficiary of
It
the
has
IRA.
to be a beneficiary. The law requires that there be a designated beneficiary, and the designated beneficiary has to be a person, has to be a real person.
Can't be in a trust.
Most of the time, that's going to be the surviving spouse because she or he gets really favorable tax treatment inheriting an IRA versus a child. A child has to distribute that IRA over 10 years. A surviving spouse inheriting an IRA, that becomes their IRA and they get it over their lifetime until they die. But when a spouse inherits an IRA, it becomes their IRA and they can then name anybody else the beneficiary. And in this day and age, where an IRA account or a retirement plan 401k account is maybe the family's largest or second largest asset only after the house, that's something that should be paid attention to. There are ways of dividing that out and using a trust to help divide that out, but it has real serious tax consequences that you need to be aware of. So
It's not
It's a
right for
last, yeah,
everybody.
it's a last resort.
Okay.
You can like swap out that asset
Yeah.
for a life insurance policy,
Oh, okay.
or if your intent is to leave a percentage of an estate to a surviving spouse, then you can execute a property agreement with a trust and a beneficiary agreement where the property agreement spells out what you're doing and the spouse is waiving rights to the home and to the other savings
Yeah.
in exchange for getting the IRA.
Yeah.
Or you can name the surviving spouse as a one-third owner of the a one-third beneficiary of the IRA and the children as two-thirds beneficiaries. Like I said at the beginning of this thing,
It
we
depends.
we can do whatever you
Yeah.
want, right?
Yeah.
We can
Yeah.
do whatever the client wants, as long as generally both clients have to agree,
Yeah.
husband and wife, and they have to know beforehand like what they want to do. And if we know what to do, then we can make all the
Mm.
assets fit.
That brings up a question I didn't have on here, and maybe you know the answer,
Maybe I don't.
maybe it's a therapist question. What are kind of the conversations that they should have before coming to talk to you? Kind of what do they need to have spelled out versus, um, I'm not going to know the implications of X, Y, and Z
Yeah.
versus W, Q, and X. What are the conversations that spouses should have specifically in blended marriages before they come to you?
The first thing 999 times out of 1,000, a husband and wife will use the same attorney to do their estate planning.
Okay.
I'll be talking to husband and wife, and the thing that they need to understand, and the thing that I explain to them is that I, as the attorney, I have a conflict of interest
Yeah.
because you each have different rights and different potential outcomes that you're looking for.
Yeah.
And if I represent both of you, then I need us to all be in agreement. If there's a dispute or if you don't know what you want, I can't advocate
Yeah.
one for the other and I can't keep secrets one for the other. So I can't hold back that, hey, if you did this, they'd get less than this.
Yeah.
I've got to lay it all out.
Right.
Okay. So in that 1 out of 1,000 times, if they don't agree, then that's when I represent the husband and the
You
wife
recommend they go to
gets
someone else.
another attorney and we negotiate.
Okay.
And that's hard, right? How do you
Yeah.
go home when your attorneys are negotiating with each other? So, so your question, what should they talk about?
Yeah.
Okay, first of all, come to understanding and an agreement. What do you both want? Um, that's where maybe you said before, maybe this is a question for a therapist
Right. Yeah.
because it may be really hard to reconcile.
Yeah.
And so if we understand what the law gives, if we do this right, the law entitles a spouse to 30% of the other spouse's assets. So
Yeah.
that's really their negotiating position or more. You have to live
Yeah.
with
Yeah.
these people, right? And so, but that's the main thing. Okay, so how much, like, what is it that I really want to have happen?
Yeah.
I always want to have, I want to be taken care of. I want to have a place to live. I want to have enough income.
Yeah.
Spouse is going to get the surviving spouse's Social Security income.
Yeah.
Depends on how they elect, maybe a pension if there is one. But then there needs to be income from other sources. And so is there going to be income from the estate? If there's a house from the estate to live in, is the income to take care of the taxes and the insurance and the upkeep?
Mm-hmm.
Where's that going to come from?
Mm-hmm.
Surviving spouse is probably going to be the co-trustee with
Yeah.
the oldest or with the child from the first marriage. So who do they want to work with? Sometimes not uncommon that the surviving spouse or that a spouse comes in and the marriage. So it's not uncommon that a married couple will come in and they'll say, look, I just want them to be taken care of no matter what.
Yeah.
So they can have everything. Whatever's left over
The
can go
kids
to
can
my
have.
kids, but we're not going to try to preserve anything.
Yeah.
So we can do that too.
Yeah.
So it just depends on what you're trying to
What the end
accomplish.
goal is. And
Mhm.
it sounds like the best thing for them to do is get on the same page first and kind of say, like, this is what we want as an outcome. We agree on that. Now we can go talk to Brent.
Yeah,
Figure
or
out.
hey, this is kind of what we're thinking, and I can help you come to the understanding.
Yeah.
Just understand that I'm
Not a mediator
I'm laying it all out
on both
and
sides.
on both sides, and
Yeah.
I'm not trying to lay anything out more favorable for one person than the other.
Yeah.
This is how it goes, and here's where we can end up.
Yeah.
And
Sounds like you might need to have a marriage counselor on speed dial, Brent. I don't know.
well,
Maybe it's
I've
just
got
like,
clients who have deliberately not married and avoided cohabiting, but have been in long-term relationships
that's tough.
to have more control over their assets and well,
If that's what you need, that's
whatever.
great, but that is tough. That'd be difficult. You brought up kind of the what was it, co-owners or joint owners of the trust, right? Um, could that ownership of assets, what kind of conflict can that create, and what kind of
Yeah.
mitigation can we put in there? Is it just spelling out exactly who can determine what and what needs to be agreed on both parties versus individually? Or
Yeah, I'm glad you brought that up because joint ownership is something to watch out for when you brought up that question about pitfalls
yeah,
later.
yeah,
One that I really need to bring up is that when you jointly own an asset, like let's say most husbands and wives own their home
yeah,
as joint tenants with rights of survivorship.
yeah.
What that means is that when one spouse dies, the other spouse
As a
is the
100%
complete
owner.
100% owner.
Yeah,
So often in a blended family, it's still done that way. They've each maybe contributed a certain amount to it, but
yeah,
that means implicitly, usually, that they each want a certain amount to be earmarked for their kids. But if you
correct.
don't change that ownership somehow, putting it in a trust,
Mm-hmm.
for example,
Yeah,
then when husband or wife dies, then the survivor owns it, period. And
yeah,
there's nothing the law does to make them do anything. So, so often we could use this, like if it's rare that a second marriage comes in and one spouse has all the money and one spouse comes in destitute. Usually they have their own assets and they're
yeah.
both equally interested in making sure. So
Protecting
we'll
both
do separate trusts in situations like that.
makes sense.
We'll do a husband's trust and a wife's trust, and then we'll make provisions in there for the treatment of the home and the property. And we may even do a deed where one trust owns half of the property, 50%, and the other trust owns half the property.
I didn't even know you could do that. That's
Yeah,
awesome.
and
Yeah,
tenancy in common. I don't know if that's the best idea, but we
but
review
it's an
that
option.
each time we look at it.
Yeah,
Um, uh, but that preserves some. You can even say when we'll do 50-50, and when wife dies, the trusts require, and by agreement, the home's sold.
mm-hmm.
Everybody cashes out.
Mm-hmm.
Husband goes off and buys his own home,
Mm-hmm.
or wife goes off and buys her own home, or whatever it is.
Yeah,
But yeah, no. So a joint trust in a blended family situation often works, but it can be tricky too. But that's
yeah,
when we would use the Q-tip.
correct. Yeah,
So
yeah, and then the provisions are all kind of laid out.
yeah,
Um,
but it's like in the event where like wife comes into the marriage and she's got all the assets, and wife comes into the marriage and she's got all the assets, and husband really doesn't have much, we can still put everything in the wife's trust, put in a Q-tip provision, leave the husband with access to property for his lifetime or until he remarries. Remarriage would maybe sever that,
yeah,
and then off we go.
yeah. No, that works. That makes sense.
You know,
Um,
I come from a blended family. My parents are each married to different people other than my other parent, and
yeah,
so I have step parents on both sides and step siblings on both sides, and they're great relationships. Now, there's been times when they've been
obvious.
tough, right?
Yeah, yeah.
It's just
Anytime
any
you,
human relationship
yeah,
can do that. But I understand those tensions
yeah.
and how they.
I think it's great that you can actually empathize,
Yeah,
like as one advising. I think that's huge because you want to be heard, and unless someone's been in that situation, it's hard to fully grasp that, right? I just remember even getting married with my wife, and just two people coming together, whether you have kids or not already, and you have
yeah,
lives together already or not, it's hard, right? Like
yeah.
it's a lot of learning and growth. So, yeah, I know that makes sense. The other question, and we've kind of touched on this a bit, and if there's no new to add, feel free to be like, well, we kind of already touched on this. So I'll just recap. But conflicts between the surviving spouse and the oldest children of the deceased. What is the biggest way that problems arise with that, and what's the solution that you can offer that kind of mitigate that? Is it clearly mapping out one is going to own and tough to the kid, right? Like we mentioned, like they're not
Yeah.
necessarily entitled to it, but if you do want to take care of them, what's the right way about going about
Yeah,
doing that, which is tricky.
that's good question. Liquidity is the issue, right? I
Okay,
mean, is there money or not at the death of a spouse? Let's
right.
say, wife dies, she has a number of, 2, 3 children. Husband's going to live for a while longer, let's expect.
Yeah.
Well, yeah, sometimes the children of the decedent just have to wait. But they don't have to if you think ahead.
Mm.
There are assets available and there are ways to take care of the surviving spouse and still provide liquidity to the
Surviving,
adult
yeah, the
children.
children.
It may not be all of it that
Right.
they're eventually going to get, but they don't necessarily have to wait 20 more years.
Yeah.
I mean, honestly, I've got clients in their 60s and 70s who've not inherited because their parents are still alive.
Yeah.
And I think that's going to be more and more common,
Yeah.
that inheritance is something that happens
Later in
much
life.
later in life. And so another thing, I have had a lot of clients just decide to make pre-death distributions to their children when it makes sense. Like, well, I don't want to wait and, my kids are 50. I don't, let's help them now while they need it,
Yeah.
30 or 40 or whatever it is, instead of waiting until they're 70 and they're retired themselves. And as long as they're not depleting their own assets for that, and making their own future a little bit less stable, I think that's great.
Yeah.
But that's the tension that you asked about,
Yeah.
is
It
how
is
long do the children of the survivor have to wait? And we can plan around that by giving money at different times
with the proper structure
with,
and liquidity and
yeah, just like you say, kind of thinking it through,
yeah.
you know.
Yeah.
And here's the other thing that I don't know if it's worth bringing up in this area, but you can't ever control how anybody else is going to feel,
Exactly.
right? I mean,
Getting back to the therapy,
yeah,
right? Let's
we've made plans deliberately so that when children get angry, they're going to get angry at their dead parents and not angry at their siblings.
Yeah.
All right. So we've made choices on that. Like, hey, I know these children are going to have a hard time with this, but I don't want them to have a bad relationship with their siblings. So I'm going to be the bad guy in the trust and I'm going to set it out to where they can't get what they want.
Yeah.
And it's not the son or the daughter who's in charge that's not going to give it to them. It's me, and I'm dead, and they might be
Mhm.
mad at me, but we're going to try to preserve the relationship with the other children. But even then, if somebody chooses to be upset, it's a choice that they're making,
And you can't prevent
and
it.
there's nothing you can do about it. I
Yeah.
mean, we can make things as clear as possible so that the upset doesn't cost a lot of money,
Mm-hmm.
but the upset might happen, and
Yeah. It's funny you bring that up. My dad was the youngest in his family, but he was the executor of the estate,
yeah,
and he was sweating bullets every time he had to make a decision. He
I know.
hated the entire process, and my mom was so mad at her mother-in-law, my grandma, because she's like, she could have just spelled this out. She could have
Yeah,
just done this. Obviously, my dad was never upset with my grandma, and he was so concerned about keeping relationships intact with his siblings, right? But it caused him so much anxiety and stress. And it's like, to your point,
yeah.
like, let yourself be the bad guy. You're gonna be gone. They're gonna have their feelings regardless of, you know what I mean? Like, it's a relationship that will be at its end point anyway. Let them have a good relationship with their siblings. I like
And
that. I like that a lot.
people make choices about their feelings all the time, and nothing you can do about it. So
For sure, for sure.
some people are
Yeah.
gonna be mad no matter what you do.
It's
So
so true. Unfortunately, but factually correct. Yes. I think the last is just kind of some practical tools and strategies that we want to talk about. Like, how can we help keep balance and support for surviving spouses while protecting children from prior marriages? So we want to help say, I've got stepchildren from this marriage. I raised them from age 4 to 22,
mhm,
and they are as much my
as
kids
right,
as my own kids are. Now I'm in a different marriage, and they're technically not my children, but they're still in my estate. I don't want my current spouse to have a bad relationship with them and disinherit them. What are some of the tools and strategies that we should look at? Or, say if I'm reviewing my estate and I'm like, I'm probably going to go to Brent, I need to rethink and figure out, um, what do I need to talk to him about? What are some of the things I should bring up if I'm coming into you in that situation?
yeah. So tell me about that situation first,
Yeah,
so I
explain the
understand it.
dynamic.
And second, we want to make sure we use the trust structure that's appropriate for your family, so that um, the in that other marriage that you're in, if you passed away, the husband can't disinherit.
Yeah,
Okay,
yeah,
we want to make sure that he doesn't have
power.
the authority to
Yeah.
do that to
Okay.
them, right? We just want to make that protection there, and that's where you have to balance his protection versus theirs, and we
Yeah.
maybe talk that through. Um, But that's it. Just being aware of that tension and being aware that there's a solution for that. A
Yeah.
lot of people don't think there's a solution, so they just put it off and they don't do anything. But there is a solution for that. And if we know about it beforehand and plan for it, then we can get there. And then just can't stress enough the power of time together while you're alive and interpersonal relationships
Yeah.
and ideas like patience and forgiveness and kindness and
Yeah.
empathy and understanding. And I mean, that's where all of our happiness comes from anyway, not from the money.
It sounds like
So,
you are part therapist then, Brent. I'm like, at this
so
point, I'm like, you've had enough experience. You're dabbling in both fields, whether you know it or not.
yeah.
No, yeah. No, that makes a lot of sense. I completely agree with that. The other one we wanted to ask about was just kind of what is a revocable living trust and what are often the benefits versus a simple will in a blended family situation?
Yeah. So, in a blended family situation, a simple will is only going to leave assets to one person or another,
Got
and
it.
it's going to leave that to them outright
Yeah.
in what we call in fee simple. They're going to be the owners of it, period. So you could use a will and you could leave, half of your assets to your spouse and half of your assets to your children. They wash their hands of each other and go their separate ways.
Yeah.
That may not be enough asset for your spouse to take care of herself. She's
Hmm.
not going to get income from anything else. So you're just going to cut the ties and move on. With a trust, you can keep these assets in the trust and still let them produce income for the benefit of your surviving spouse while they continue to grow and eventually go to your children.
Yeah.
And that's where I was talking before about, that tension of liquidity. How long are these children going to have to wait? No, I don't know. How long do you want them to wait? Because we
Yeah.
can write that in. But the trust has the option of keeping the assets all in one place where they continue to produce income and are protected for both parties. In a nutshell, the will just cuts it in half or in whatever portion you want and gives it to them and they move on.
Yeah.
And that might work, in a
Yeah.
larger estate. Boom, everybody goes their separate ways
Everyone's
and
got plenty to be happy.
yeah, nobody has a problem.
All right. So we kind of talked through a Q-tip a few times. I just want to really quick kind of recap. What is the Q-tip trust or a Q-tip in the trust? What does it and when does it make sense in a second marriage?
Okay. So it's a separate trust within the trust. So we create a revocable trust. When one of the spouses dies, you've got assets that are put over into this separate trust within the trust, and they're held there.
Got it.
They're held there and until whatever conditions are satisfied. Usually the surviving spouse
Yeah.
dies. But let's say so we put the home in that Q-tip trust. The surviving spouse can live in that home for as long as she wants. If the husband wants to provide money to pay for the taxes
Upkeep.
and the insurance and to keep the home in good condition so that when it's time to sell, it's not all run down. Let's say he leaves another $500,000 in that Q-tip trust as cash. Well, that can be invested and it can earn income.
Hmm.
So let's say it's making 5%. So it's making $25,000 a year, right? So that money can be used towards the upkeep of that house. And it stays there and maybe it's earning more than that, but that's how much it pays out.
Yeah.
And then when everybody passes away, the home has increased in value. That cash has at least maintained its value. It's probably also increased
Yeah.
in value. The home's in good shape. There's cash in there when the surviving spouse dies or those other Q-tip conditions are met, then that can all be liquidated and then given to the beneficiaries of that trust as set forth before, which are the children of the first person to die. Does that make sense?
Yeah. And so the one follow-up I was going to have, I think you basically already answered, is like, how does it provide that income? It's basically on top of whatever asset it is, say it's the house, you'll also put some liquid cash and then it can be invested and then you can
Or
take
stocks
the,
that
okay,
produce dividends,
got it.
or you could put another rental property in there, and the rental property
Income. Okay.
income comes in. And you generally don't want that trust to have income at the end of the year. So there's
Yeah.
usually going to be a provision where all of the income gets distributed one way or another.
Yeah.
We talk about that. But But that's what happens. Yeah, you're right. There has to be some kind of income production
Okay.
somewhere.
Okay. And so that's kind of the big key factor for a Q-tip
Right.
is there needs to be some income producer.
Well, there doesn't have to be
Oh, but
because
there usually is due
because if
to
the
the upkeep.
surviving spouse has all the money that they need,
They
maybe
can
we just leave
upkeep on their
assets in
own.
there or whatever.
Okay.
But yeah, if there's but usually if we leave a large lump sum of money in a Q-tip trust, it's going to be invested and it's going to be
For sure.
making money.
Yeah.
And so there's an amount that is set aside, and let's say we put $1 million in there. The provision might be to distribute all of that income to the surviving spouse,
Mm-hmm.
or what, 5, 6% per year, whichever's more,
Right.
and and that just should continue on in perpetuity.
Okay.
And then she's getting, $50,000, $60,000 a year from
Yeah.
that, from the trust, but that money maybe grows, and
And that takes care of both parties.
yeah,
One much later, right?
it's protecting the one for the other. And you got to pay attention to your trustees and to your
Yeah.
investment managers, that there's, the trustee is somebody that can be trusted. And the trustee can't just take it all, and like he can't put it all on Tesla stock, but
Put it all on black, right?
yeah,
Yeah.
she can't also take it and stick it in the bank. You've got to make a reasonable return and act as a prudent investor,
Okay.
but yeah, you're trying to do both. You're walking that line between giving income to this person and protecting the principal for this person.
Got it. No, that makes perfect sense.
Yeah.
And it sounds like it's most useful when you're trying to take care of somebody right now and somebody else a little bit later. Is
Yeah.
that a fair?
That's what it's for. That's what it's for.
Awesome.
And a will cannot do that.
Yeah. No, that makes sense. Okay, the next one.
Okay.
Should you keep certain assets separate in a blended family? What's kind of the advice on
Yeah.
that?
Yeah, again, it depends, but in general, most families that go into a blended family situation know what belonged to each other before they came in.
Yeah.
And they might have either an implicit or an explicit understanding of how they're blending their current income to build assets together. But they generally know what belongs. And generally, the family home from one spouse
Is a large.
usually tries to stay
Yeah.
in the family of the original,
Yeah.
unless there's been some money put in by the new spouse to kind of buy into that. And I hate to put it that way, but it is a business relationship at the end of it all anyway.
Yeah.
So, and then usually retirement accounts are kept separate,
Yeah.
and that's as much for those can never be held jointly, and they can never be held by a trust. They have to be owned by the individual.
Yeah.
But yeah, I mean, that's an important question that you just ask when you're doing all this planning as well. What's mine, what's yours, and what's for my kids, and what's for your kids? Or
Yeah.
if we want to explicitly treat them as our kids, how do we do that so that
Equally
somebody
and
doesn't change their
fairly.
mind later on?
Yeah.
And that's a hard conversation to have sometimes, because it presumes that one of the spouses is not going to hold up their end of the bargain.
Right.
And you don't want to come into a relationship
Yeah.
feeling like that they can't be trusted.
Yeah.
So I'll be the bad guy and point out that they can change their mind, and if
Right.
they decide to go forward that way, then that's fine.
Yeah. No, that makes perfect sense. Um, let's see the other one. How do you structure your plan to reduce risk in family conflict?
Um, Using these types of structures and having clear
Clearly spelled it
communication.
out.
Yeah.
Essentially, if we can eliminate litigation possibility, we've
Yeah.
limited family dispute. Is
I
that
get-
kind of a
yeah,
fair?
the cliche, good fences make good neighbors. If it's all spelled out,
Yeah.
then there's not a lot to fight about.
Excellent.
That's the idea, is we make it so that there's nothing to fight about. We put stuff in the trust that if anybody tries to fight the trust and starts a lawsuit against the trust, then they're treated as if they died before
Yeah.
me, and that therefore they're cut out. They don't get anything.
Yeah.
And that's not always enforceable, but that goes a long way in helping keep people honest.
Reduce. Yeah,
Yeah.
it reduces the likelihood for
Yeah.
sure. Yeah. You can't prevent litigation, but you can reduce the risk of it for sure.
Yeah,
right?
you could create risk to litigation.
Yeah.
Yeah.
Awesome.
So,
All right. I think that's everything. Thank you so much.
yeah, you bet.